some limited food items which could be purchased in order to eat something in the cell in light of the general terrible state of the prison food that I've already described. Towards the end of my sentence minimum, the prison authorities told me that if I wanted to have any chance at all of making parole, which is already a slimmer than slim possibility as it was, I would have to take and complete the sex offender training program. The problem with taking that program, however, was that there was an explicit guilt admission requirement tied to the program. Not only would all the participants be expected to admit guilt to the instructor and to the other prisoners, but they would also be expected to give details. Simply saying that one was guilty wouldn't cut it. They wanted a blow-by-blow account. Doing so verbally was insufficient. They wanted everything in writing. Failure to complete any aspect of that would result in automatic removal from the program, with the prisoner being deemed to have refused to participate. Kind of borrowing off of the AA philosophy, we have to admit you have a problem before anything can work. But totally inflexible to the reality that people are wrongfully convicted, including in sex offenses. So zero flexibility there. Now I was looking at parole as a way of trying to regain my freedom before anyone else in my family had passed away, because my grandmother passed while I was wrongfully incarcerated. But yet I couldn't bring myself to complete all the components of that program. And so in the end, after a lot of soul searching, I decided I would not take the program. One of the best decisions that I ever made. When I went to the parole board, I knew that the parole board was in the habit of rubber stamp denying parole applications to anyone who had been convicted of a violent crime, regardless of whether they could show they had been rehabilitated and that if released, they would pose no threat to society, that they would lead a law-abiding life. Knowing that that was the case, I tried to protect myself from having that happen to me. I kept raising the issue of my innocence and referencing the DNA. But the parole board was unwilling to consider even the mere possibility that I might be innocent. At the end of the interview, one of the commissioners asked me a question about an aggression replacement training program, and I was able to give him the answer, demonstrating I'd learned the material in the class. That's when a different commissioner piped up and said, "That's good, Mr. Deskovic, because you're going to need those skills once you return back to society. Good luck." The procedures include the decision right there on the spot. They instead nail it to you via institutional mail. Considering how the interview ended, I actually walked around the prison for the next 3 days that I had somehow defined the odds that I could go home. Instead, when I got the decision, it noted that I had a good disciplinary record, that I had an excellent educational record, that I had letters of support, including that of a prison employee, but that nonetheless I committed a brutal and senseless crime, and in their view, to release me would be somehow to lessen its seriousness. They ordered me to appear another 2 years later. Now at that point, considering I knew many prisoners who were working on years 25 and 30, all for 15 and life sentence, in which they go to the parole board, be turned down, serve another 2 years, make a reappearance, be turned down again, and kind of have that cycle prepare in a seemingly never-ending cycle of perpetuity, I felt fairly certain at that moment that I was going to die in prison for a crime that I didn't commit. Let me share with you how it was that I came to be exonerated. While all that was happening, and much more that I'm passing over because we do have some time constraints, I was simultaneously appealing my case throughout the court system. I went to the appellate division, the first court one must go to. My lawyer argued 10 issues of law, including that I was innocent, making 3 arguments about that, utilizing the DNA, that there was legally insufficient evidence, that the prosecution hadn't proven guilt beyond a reasonable doubt, and that the verdict was against the weight of the evidence. She also argued that the interrogation, that my Fifth Amendment rights were violated. And then she argued a bunch of other points of law that are really irrelevant to what we're doing today. And the appellate division made their ruling. They ruled that there was nothing wrong with the way I'd been questioned, and furthermore, they wrote in their opinion that there was overwhelming evidence of guilt. I still don't quite understand that ruling to this day, considering that the DNA was in my behalf. They ruled against me 5-0. My lawyer moved to re-argue the case in front of them, arguing that their decision was running contrary to the facts and the law, but the re-argument motion was denied. We went to the Court of Appeals, New York State's highest court, where the procedure is that you have to get permission from the court before they'll agree to allow you to fully argue the issues and then to give a ruling. The Court of Appeals ruled that there was no merit in law to justify reviewing my case, and so they were declining to give me permission to appeal to them. I then went to federal court, filing what's called a petition for writ of habeas corpus, which is when a state prisoner is arguing that his or her conviction was running contrary to the Constitution and that the state courts had failed to correct the situation. Once again, I had my innocence as one of the arguments, my Fifth Amendment rights, and a couple of other constitutional issues which are not really relevant to today. Now, at that time, there was a act which had just been passed into law a year before, the AEDPA Act, which the Anti-Terrorism Effective Death Penalty Act, which had been passed in 1996 by Congress and signed into law by then President Bill Clinton. In relevant part, that act said that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. So the confusion in the court system was, how would this new law apply to cases already in the pipeline? And so different jurisdictions were answering the question differently, and so my lawyer reached out to the court clerk to ask for clarification. Was it enough that my petition be postmarked on the due date, or did it instead have to be physically filed and in the building on the due date? The court clerk told my lawyer it would be enough that it be postmarked, but that information turned out to be false, and as a result of that, my petition arrived 4 days too late. The Westchester County District Attorney, who now has a judge show on several television shows, Janine Pirro, her office took the position that those 4 days were somehow prejudicial to the people, and therefore my case should simply be dismissed by the court as being late without them even looking at the merits of the issues. That's the position that the court adopted, and as a result of that, I was now time barred, meaning I was no longer allowed to argue my issues directly, but instead I was relegated to arguing that this procedural ruling against me was inaccurate. So we appealed this procedural ruling to the Federal Court of Appeals, where we argued in front of two judges, Judge Rosemary Pooler and future United States Supreme Court Justice Sonia Sotomayor. My lawyer argued that this was a delay caused by the court clerks in misinformation and not by my lawyer or me. Legal mumbo-jumbo aside, seems like a reasonable enough argument to me. Secondly, that upholding a ruling like that would cause a miscarriage of justice to continue, which kind of indirectly leads back to the DNA not matching me and my innocence argument. And thirdly, that overturning the procedural ruling would open the door to more sophisticated DNA testing, which would go on to clear me 7 years later. Once again, the court, the DA opposed, and once again the court ruled with the DA. My lawyer moved to re-argue the case in front of all of the judges, but the re-argument motion was denied. We then went to the U.S. Supreme Court, which agrees to hear only between 2 to 5% of the total number of cases in front of it. They declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, at that stage was to find a lawyer who'd take my case for free, for I had no money to hire one, hope I could find an investigator who'd work on a similar basis, and hope that in tandem they could both find some previously unknown evidence of innocence, without which the court would no longer let me in to the courtroom. So I wrote letters for about 4 years, looking for people who could help me, either directly or indirectly, very rarely hearing back from anyone. Eventually, I accidentally got in contact with an investigator. I wrote a book author in care of a publishing company, but they sent it to an investigator instead. To make a long story short, she connected me to the Innocence Project in New York. She wrote them letters. She lobbied them to take my case. She got other respected legal entities to do the same thing. Eventually, they agreed to take my case. By this point, the prior DA had left office, and the new one allowed me to have further testing that the other had blocked me from getting. They took the crime scene DNA evidence, which already didn't match me, and they ran it through the DNA data bank, and it matched the actual perpetrator, whose DNA was only in the data bank because left free while I was doing time for his crime. He killed the second victim 3.5 years later, who was a school teacher and mother of 2. So on September 20th, 2006, my conviction was overturned and I was released. All the charges against me were dismissed on actual innocence grounds on November 2nd, 2006. It was at that point that I was free to try to rebuild my life. It has been very difficult to put one's life back together again after being through an experience like that. The culture is much different. My extended family become strangers to me. Technology was much different. I mean, to give concrete examples, we didn't have cell phones, GPS, the internet didn't exist. When I meet with members of my immediate and extended family, it's kind of an awkward experience because even though I know who they are intellectually, when you spend large amounts of time away from people, they become different people, and I'm a different person also, so the gap is much larger. Worked a lot with mental health experts in assisting me in readjusting to being in society and in coping with the psychological after effects. I was released with nothing. Ultimately, through lawsuits, I was compensated, but that took me 5 years. I wasn't given anything prior to that. I very nearly ended up into a homeless shelter because I didn't have a place to stay. If I had to make a trip to the city, I wasn't above putting cereal in a bowl and putting it in a backpack because I couldn't afford to buy anything out. I was never able to obtain gainful employment. First of all, I had been out of the job, well, I really was never in the job market because I was 17 when I went away, but then also I didn't have experience. There was a stigma around me, in terms of, yes, you were there wrongfully, but you were in prison for 16 years. How much of that actually rubbed off on you? Is it safe to have you around? Other people were concerned. Well, I'd like to hire you, but if I do, I'm afraid people won't patronize my business and I'll go out of business, so I can't hire you. So there were all those different issues. So it was a very difficult existence. Thank God that Mercy College, which had given me the scholarship to attend their school, they eventually allowed me to stay on their campus. So I got some compensation, and I wanted to reach back to similarly situated people who were in the same position that I was in. And that's why I started the charitable organization. I used some of the compensation that I got to launch the organization. Hopefully you'll look us up, and there's different ways people can help. I don't know how to use this phone. I'm technologically challenged. I had this phone for a month, and I thought I turned it off, except that I didn't. So I'm sorry for the background noise. It's kind of an embarrassing thing here. But, I'm living example, I guess, as I wrap up. I mean, I'm living example that, wrongful convictions can and do happen. It's cross racial lines. It crosses socioeconomic lines. Obviously, somebody who has resources is better off to defend themselves. They can hire lawyers rather than someone who doesn't. But it can happen to someone who has financial means as well. I had never been arrested for anything. None of my friends were involved in crime. I was not a high school dropout. In fact, I was on my way to school when this originally happened to me. It happened to me. And it can happen to you, the person on the lawn here next to you. It could happen to your son, your daughter, your best friend, a relative. So I encourage everybody to remain active, to participate in the coalition, to be involved in wrongful convictions, to come out to events. Check my organization out on the internet. It's named after me, the Jeffrey Deskovic Foundation for Justice. Thanks a lot. Thank you for listening.